Okay, let's have a look at this. And feel free, as I said, I want to hear any questions that you guys have got. And this is going over all the content. Some should be familiar, some should be starting to become familiar, and some will be new, some stuff about tribunals and things. We started by talking about the features of a good law. And we said there were a number of features. The first of those is that it must balance the individual rights with the community good. What that means is, as individuals, we've got the right to do different things, and it has to balance against that community good. So, for example, we could have a curfew at 4 o'clock in the afternoon, and that would get rid of a whole lot of crime. But individually, we've got a right to be out and about and enjoying ourselves. So there's a balancing between those two things. The laws should be clear. The Australian Law Reform Commission recommends that plain English be used in laws. Consistent and stable, the change shouldn't be fast. And this is one of the reasons we don't make laws retrospective, because people need to be able to trust that laws are basically stable. The things that we have to do today, we understand and aware. Backdating laws would not be a stable way of looking at things. And they should apply equally to all. So no groups of people, maybe politicians, should get preferential treatment. And we've talked about some of the elements of politicians being able to say what they want, parliamentary privilege in Parliament without being sued. And so there might be some people who question whether that's actually right or not. And laws should be capable of being enforced. It's easy if you have a speed limit, it's very easy to see how that's enforced. But if you have a law that revolves around the sort of discussions people have, well, it's hard to overhear and understand what discussions are going on. And in terms of laws around terrorism, we're getting to that point where the people are looking at that. So, history of law in Australia. When Australia was settled, it was declared to be terra nullius, an empty land or a vacant land, a land belonging to no one. And that meant that British laws would come and be important to us, right, because it was the British who were settling. So that's why a lot of our legal system is based on what happens in Britain. We talk about two sources of law, and hopefully you're becoming familiar with these terms. We didn't talk about these in the three differences we've just been through between criminal and civil, but here they are. Statute law. Statute law is law made by Parliament, right, and it's most common around criminal law. Common law is the law made from the decisions of judges, and we'll look more at precedent, which is important to this, and it's more common in civil law. Let's start by having a look at Parliament and the law. So if we look at the structure of Parliament, there are two houses in the Federal, the Commonwealth, the Parliament down in Australia. And it was very interesting yesterday, Prime Minister Tony Abbott, Parliament is sitting at the moment in Canberra. He chose to take the government jet up to Sydney in the morning before Parliament to make an announcement and fly back down. He and Joe Hockey about housing, and was criticised with people saying the cost of that was up to $29,000, and that was not a great use of resources when all the journalists are down in Canberra. So it's based in Canberra, and there are two houses, the House of Representatives and the Senate. So in a very, very rough way, a law is passed. It starts as a proposed law, a bill, voted on by the House of Representatives, then the Senate, and signed in by the Governor-General, known as Royal Assent, and becomes an Act of Parliament. So it starts as a bill and becomes an Act. However, this is a very, very simplified version of the process, which is in the textbooks if you look a little further at. The Prime Minister, currently Tony Abbott, the Prime Minister is the leader of the political party that has the most votes in the House of Representatives, and he or she will be a member of the House of Representatives. And that's where they come from federally. At a state level, we're talking about the Premier, Queensland, Anna Palaszczuk. So there are 89 seats in Queensland. Queensland only has the one House of Parliament, so it's all the lower house where people are directly elected. The Premier comes from the party with at least half of the seats. The current Parliament, the Labor Party only has 44. It doesn't quite have half the seats, but an independent, Peter Wellington, has said he will support the Labor Party, and that allows them to form government. Queensland is different. Every other state and the federal parliament has two houses. We only have the one. Unicameral parliament, the one house of parliament, and that's because in 1922 they voted to abolish the upper house. And what that means in effect is it's easier to get legislation through, but whichever side of politics is in power, they have an extraordinary amount of power because there's no second house reviewing what they're doing. Separation of powers. This is an important idea. It talks about the fact there are three different roles in power. One is the making of power, the legislative power. The second is the implementing of law. That's done by the ministers, the executive power, and the interpreting of law, the judicial power. So legislative, executive and judicial. The Parliament is the group that makes the law, that votes the law in. The ministers, they have the executive power, they implement the law. How are we going to work this through? And the judges interpret the law. So for example, let's say we decided we were going to have no speed limits on some Queensland roads. That would pass through Parliament. The minister would then work out exactly how they're going to do it, how you're going to signpost it, how you're going to educate people. And the judges, when they come to implementing the law, they may have to make some subtle decisions. For example, there are laws about dangerous driving. Perhaps someone who's driving at 180 kilometres per hour, they might not be breaking the speed limit, but they may be able to be charged under dangerous driving laws still. So they're going to have to make interpretations about the law there. It's relevant at both state and federal levels and comes from the Constitution. This brings us nicely to the Constitution. It's the primary piece of legislation that sets out the levels of government and the authority and limits of their power. Okay. It's that says if Queensland were thinking about putting together an army, can Queensland do that? It sets out the powers. Each state also has their own constitution. So it divides powers between the Commonwealth and the state. Now, very importantly, the big law says that if the state law is inconsistent with the common law, with Commonwealth law, right? So if the state law, maybe the state law says that people have a right to assisted suicide, to take their life and end their life under certain circumstances, the state can legislate. But if the Commonwealth then goes and says that's a crime, it is the Commonwealth law that prevails. So there are three different types of powers in the Constitution: the exclusive, concurrent and residual. And we haven't looked at this, so it won't be super familiar yet, but it's just coming on. It shouldn't be too scary. Exclusive powers are those things can only be done by the Commonwealth. And two examples there. It's only the Commonwealth that can make money. That's one of their jobs, or have an army. We can't have a Queensland pound that we start using to pay for stuff. We can't raise an army in Queensland. Then there are concurrent powers where both the Commonwealth and the states can make a law, which is most areas. And as he said, Section 109 of the Constitution says that when a law of the state is inconsistent with the Commonwealth, so the federal, the Canberra government, it's the Commonwealth that prevails. Residual powers, these are the ones that are left over after the other two, and they remain with the state. So if nothing else is mentioned, then the states have the ability. So you've got to be able to recognise those three different levels of power. Changing the Constitution is not easy. So you have to have a vote in Parliament to say we're going to have this referendum. You have to have overall more than 50% of the voters. That's not hard to vote for the change, but this is the hard bit. A majority of voters in a majority of states must vote for the change. We have 6 states in Australia. That means 4 states have to vote yes for a change. If it's 3 and 3, there's not going to be a change. It's considered hard to change the Constitution. Perhaps one of the more famous changes were in the 1960s when Indigenous Australians were allowed to vote. A famous, somewhat recent situation where there was a referendum but the vote was against the change was for us to become a republic. Right? So to get rid of the constitutional monarchy, get rid of the Queen as our head of state, that did not pass. So that's Parliament. We now look at our second area of law, which is the court, and we start with just a quick recap of where we came from, the British legal system. And to add to this now, our court system is an adversarial system. Both sides present evidence in order to prove their case. Our court hierarchy has 3 courts in Queensland: the Magistrates, District and Supreme, and they hear both civil and criminal cases. The difference: civil cases are disputes between 2 or more parties. Criminal cases involve offences against the community, so it could be things like littering and murder. Civil case might be a dispute around a contract. Now, to get a decision in your favour, you have to prove in a criminal case that the act has happened beyond reasonable doubt. In a civil case, it's just on the balance of probabilities. It's easier to prove for a civil case. Here are some differences between civil and criminal law. A case has to be proven beyond reasonable doubt against balance of probability. Criminal usually has a jury, civil rarely has a jury. Criminal comes from statute, law, acts of parliament, civil from common law, and the different punishments. Let's start with the lowest of the courts in the court hierarchy, right? The Magistrate Court is the first level of court. There are some smaller tribunals that sit underneath it, but the first of the standalone courts. It deals with less serious offences. Traffic infringements are a good example. Importantly, all criminal matters that are going to be heard in the District and Supreme Court, so more significant criminal matters, start with a committal hearing in the Magistrate's Court. That is to check whether prima facie, on face value, there is enough evidence for the case to go to trial. Civil cases will be heard if there's less than $150,000 dispute. A builder is suing someone for, say, $60,000 for not having paid their contract. That will be heard in a Magistrate's Court. There are no juries in Magistrate's Court. As we went along, we saw just a magistrate doing the work there. We now go up to the District Court. They hear criminal matters that are more significant, maximum penalty up to 14 years, and disputes involving amounts of $150,000 to $750,000 in terms of their civil cases. Supreme Court, the highest court in Queensland. It includes two different divisions, just where cases are heard, but also the Court of Appeal, which is a bench of 3 to 5 judges who hear cases from the districts and Supreme Court that are allowed to be appealed. Here's the most serious criminal cases. So the murder case, for example, that happened recently around Gerard Baden-Clay, that was heard in the Supreme Court. And disputes involving more than $750,000. Occasionally juries are used in civil disputes. And at the top is the Court of Appeal, part of the Supreme Court, a panel of 3 to 5 judges that hear appeals from District and Supreme Court, where people are given are allowed to appeal. It's not an automatic process. So sitting above the state courts is the High Court of Australia, and it has two main roles: constitutional issues. So there was some discussion around whether it was constitutional for the government to be funding chaplains in schools because of the fact that chaplaincy had a religious affiliation. And so that was heard in the High Court, and also hears appeals from other state courts. Used to have the Privy Council that you could appeal to in London, but that's no longer the case. So jurisdiction is the fancy word that means which case a court is able to hear. So when we hear jurisdiction, we're thinking about what are the limits of the cases they can hear. So for example, a district court hears cases with the amount in dispute for civil matters of between $150,000 and $750,000. Two different types of jurisdiction: original, where a case is heard the first time it goes to court, and appellate, which is the appeals from the cases. So these are the two levels: original and appellate jurisdiction. Now we're thinking about the effect that precedent has on it. So courts have an important role in creating law. We've talked about this before. Statute laws act of Parliament, but common law comes from the decision of judges. And the doctrine of precedent is where a legal principle from a previous case is used to decide the same issue in a later case. So lower courts are bound by the decisions of higher courts in their hierarchies. This is a binding precedent. Where the facts are the same, the decision has to be the same. So think about Facebook and social media. A judge in the Supreme Court decides that liking a comment is equivalent to publishing it, then the judges in the District Court will follow that ruling because that is a lower court in the court hierarchy. You can distinguish a case. If there are factors that are different, then it'll said to be distinguished from the precedent. And overseas cases may influence Australian courts as part of their persuasive authority. When judges give their decision, they're giving two parts, and this is something we have not looked at yet, and we will look at in more detail. So there's two words that describe what we find in a judge's decision. Ratio dicendi, which is the reason for the decision. It's the core reason for the decision. And the obiter dicta is something said by the way. So on the next slide, we'll have a look at an example, and we'll see if we can pull out what is the core part of the decision, the ratio dicendi, and the obiter dicta, the comments by the way. Again, we've got a judge making a ruling on defamation from social media. She says the defendant has published material because she liked it on Facebook, and it's clear that many other people have seen the defamatory comments. She then goes on to say, however, if there was no evidence that anyone else had viewed the page and the defendant had removed their like of the page, this would not be considered publication. Out of that, the core part of her decision, the ratio dicendi, is the defendant has published material because she's liked it on Facebook. Her comments, by the way, which don't directly relate to the case, but say if there's no proof that someone else had seen it before she removed her like, it would not be publication. So they're the two things we'll be looking at. So that's an example of common law that comes from courts, court-made law, which is different from statute law, which is law that comes from Acts of Parliament. Two quick comments about a couple of smaller courts. The Murray Court is a special part of the Queensland Magistrates Court. It only sentences people, Indigenous people, who've pled guilty to an offence. So it doesn't hear the trial process at all. It's just involved in providing sentences at the magistrates level. And you often hear, as well as courts, we often hear about tribunals. Tribunals are set up. They don't require lawyers. They're often not as formal. They might investigate, for example, for a long time in Queensland, there's a small claims tribunal, and just allow people who had very small disputes to go along, represent themselves, and deal with those matters. A lot more relaxed in how evidence is presented, and there's not the same level of focus on precedent. So there's some of the differences between courts and tribunals. Last thing we want to look at are the people involved in the legal process. The judges, they ensure court processes are followed and decide the sentence in criminal matters. In civil matters, they make the ruling and decide the penalty. The jury, usually 12 people, hear the evidence and make the decision of guilty or not guilty in criminal matters. And they're looking to see, has the case been proved beyond reasonable doubt? The defendant is the person who's been charged, accused of the crime. Prosecution bring the case in a criminal matter. They follow the work of the police in building a case.